SJC-11209, Commonwealth v. Jeffrey McGee.
Is this a class scenario under?
We'll just wait one moment and let the courtroom clear.
Fine.
All right, counsel.
Morning, Your Honors. May it please the Court, Eric Grant for Mr. McGee. Your Honors, this is an appeal from convictions of murder in the first degree and other offenses. At trial in this case, it was not disputed that the defendant was the person who committed the killing, the victim being his wife. The only question for the jury was the degree of the killing, which turned on the defendant's state of mind, whether the killing was premeditated, as the Commonwealth argued, or whether it was committed in the heat of passion, constituted a voluntary manslaughter, as the defendant argued. We say that the jury's consideration of this somewhat fragile question was skewed by the inflammatory demonstration that's the subject of the first issue in our brief. And here's what happened. The prosecutor brought a couch into the courtroom and had the victim's little son, Gavin, who was 6 years old at the time of trial, and
He was 4 years old at the time of the offense.
not quite 4 years old at the time he witnessed this incident. The prosecutor had him reenact his mother's position on the couch, quote, "when your dad was killing her," end quote. This is how the prosecutor put it to him in asking him to perform the demonstration. Now, of course, it's true that demonstrations are ordinarily within the judge's discretion, but like any other evidence, they still
How long was it? How long did the actual reenactment take?
The record doesn't show that, Your Honor.
'Cause
It was long enough for him to sit down on the couch and
how many
assume
how
the
many
position.
how many questions were put to him as he was doing that? I mean, that may give you some sense of.
No questions were put to him as he was conducting the demonstration, if I'm correct, from the record.
Now,
He
he had
first-
not been able to really, I mean, hadn't he, when he testified, said something like, Mommy's head was in the sofa, and that this demonstration was actually something that could clarify that what he was showing was that the mother's head was between the sofa cushion, between the cushions, which is something he really didn't have the vocabulary apparently to articulate.
The demonstration did add something to his verbal description, but in our view, it wasn't really enough more to outweigh the inflammatory prejudice of having him reenact his mother's position.
But the jury had just heard him testify to being present when his father was killing his mother.
Yes.
And the jury was already, if it was something that was going to upset them, that's what upset them.
Well, that would be upsetting, but I think it would be even more upsetting to watch this child have to demonstrate the position that he was witnessed his mother in when she was being killed by the defendant.
Wasn't the judge, didn't she do a voir dire? Wasn't she very careful in the way that she limited the demonstration?
She heard an offer proof from the prosecutor several days in advance when this was discussed on pretrial motions. She was asked by defense counsel to voir dire this reenactment, this demonstration. The judge instead accepted the prosecutor's representation about what would be shown and the fact that Gavin would not be getting very emotional during the course of it. The answer to your question is there was no voir dire of the demonstration despite defense counsel's request. And although it's
But
not...
that, in fact, let me just ask you this. In fact, the demonstration that did happen was not inconsistent with what the prosecutor had said, nor did, at least as I I didn't see that he got emotional at all in doing it.
There's no showing of that he got emotional. The question is, did the jury get emotional? And we can see from the record,
They were emotional before it started.
well, defense counsel points out that 2 jurors were already crying during the testimony before the demonstration was conducted. But that didn't mean that it couldn't be made worse by the demonstration. And our position is that common sense tells you that it would be made worse.
Anything on the record that suggests it was made worse, that more jurors were crying, that the intensity of the crying was any
No.
different? Or is it just common sense we're supposed to?
The answer is there's nothing in the record to show that more jurors were crying. But in our view, Your Honor,
Did give a, I forgot the word she used to describe it, a carefully crafted instruction?
carefully crafted instruction, which evidently was of no effect whatsoever if 2 jurors are already crying before the demonstration takes place.
Well,
The instruction was given when Gavin stood up to take the stand.
okay.
The judge told the jury's, it was basically a standard instruction, not to be influenced by sympathy or emotion.
It was quite detailed.
And within 10 pages in the transcript, we have 2 jurors crying.
Well, would you argue then that the child shouldn't have testified?
No, the Commonwealth was entitled to put this child on. He witnessed the event.
So then there would have been tears.
Well, yes.
So the tears, the fact that there were tears doesn't make it necessarily inadmissible. So what you're saying is the demonstration made it worse.
Yes, indeed, Your Honor.
Now, the Commonwealth says the demonstration was necessary to show that where she was unconscious after being strangled was precisely where she was found, and therefore that there was nothing that she did which would have triggered his grabbing the knives to stab her, and therefore it goes to premeditation.
Well, the Commonwealth, I'm glad you mentioned that, Your Honor, because in our view, there wasn't any nothing probative was added by this demonstration. And that, as you say, the point of the demonstration seemed to be to show that the victim was unconscious after the strangling and before the stabbing. But there was already
right, okay. And why would that not go to the fact that there was nothing that she did which triggered his grabbing the knife to
Well,
to
it
stab
would
her?
go to that, but there was already plenty of other evidence that the victim was unconscious after the strangling and before the stabbing, and therefore was not in a position to offer any additional provocation. And here's some of that evidence. Some of it, the main part of it, comes from Gavin's own testimony apart from the demonstration, prior to the demonstration. Gavin testifies that while the defendant is strangling his mother, she's no longer crying. He testifies that while the defendant is strangling his mother, she's no longer moving. The prosecutor asked him, what was her body doing at that time? Answer, like nothing. And the third thing is that Gavin gave no testimony that after the strangling, when the defendant went into the kitchen briefly, that his mother tried to get up and run away, which is what one would expect a person in that situation to do if she were still conscious. So Gavin's testimony makes this point pretty clearly, I'd say. Furthermore, the medical examiner testifies that her findings showed, quote, strangulation with asphyxia, end quote, which doesn't necessarily mean asphyxia as a cause of death. She said that wasn't the cause of death. It just means a deprivation of oxygen, which would be of the sort that would render someone unconscious. So there's that. And the medical examiner also gave no testimony that the victim had any defensive stab wounds. She testified that all of the injuries to the victim's hands and arms were blunt force injuries. And that means to us that during the stabbing, the victim wasn't struggling, she offered no resistance, and if someone's being stabbed 6 times, that can only be because they're unconscious. So I don't think the Commonwealth needed to present this inflammatory demonstration to make the somewhat convoluted point, to get by this convoluted process to the point that the victim was unconscious and therefore offered no further resistance. So, in
Now,
our view,
I gather your sister will stand up and say if they were so overwhelmed by passion, they would not have acquitted him on the assault with intent to murder charge.
I gather she will say that. And our answer is that this demonstration, the problem with this demonstration went only to the first-degree murder conviction. The jury undoubtedly had other reasons to acquit Gavin, to acquit the defendant of the assault to murder Gavin. And I seem to recall, I couldn't locate in the transcript, unfortunately I was not briefing counsel. I seem to recall something about after the incident, after the car crash, the defendant saying to the responders, "Don't worry about me, see about Gavin." And that's what sticks in my mind. My sister will correct me if there's indeed no evidence of this, but I saw it somewhere, I think. And I think that would be a complete explanation for why the jury didn't think that the defendant was trying to murder Gavin, whereas the prejudice from this demonstration still could have, certainly went directly to the question of the killing and could have, certainly would have had the potential to prejudice the defendant on the first-degree murder charge. Let me turn to.
Can I ask you this? If there,
Yes.
if there had been a camera in the house which had captured this, and Gavin testified to what he remembered, and then the Commonwealth offered to show the film of it, would that be prejudicial?
If there had been a camera recording the demonstration,
Recording what happened in the house,
Yeah. There just happened to be a camera up on the wall at the time.
showing this.
it wouldn't necessarily, except that, I mean, I think the Commonwealth would have offered one or the other. But as matters stood, there was a description in Gavin's testimony, and what was added by this demonstration was not sufficient. Just didn't add enough to outweigh the prejudice of having this young man come in and demonstrate what his mother looked like when she was being killed.
Right.
Could you tell me what evidence you proffered that there was provocation prior to the strangling? What did the evidence show that the defendant learned immediately before the stabbing?
Well, this comes from a combination of things, which I'll just summarize in advance. There was a connection between the two calls, which the victim made to her lover at 8 o'clock, her two lovers.
And which one? Not Mr. Vigilant, I gather.
No.
So
There was one named Huey and one named...
There was no call with Vigilant that would reflect information about the threesome.
There was,
Sully and
that's a separate matter. There were calls to Sully and to a fellow named Hoey or Huey. That occurred at 8 o'clock. Gavin testifies that he sees his parents fighting. He testifies that the fight has something to do with their looking for their cell phones, which they ultimately find. And then the phone records show that the voicemail on the victim's phone was checked at around 10 o'clock. And in the light most favorable to the defendant, all of this could be found to have occurred prior to the killing. So it's the inference of heat of passion to be drawn from those pieces of evidence. Now, there was another piece of Gavin's testimony that suggested that maybe some of this stuff happened after they'd all gone to sleep. But at the charge conference, the judge recognized that, yes, that was one interpretation, but there was another interpretation, more favorable to the defendant, which is how we look at these things, and that on that interpretation, these matters would have occurred prior to the killing.
the voicemail, was there evidence as to what was on the voicemail? I mean, there was
no
nothing from
evidence as to the content.
Vigilant, right? Or Vigilant, I don't know how to say his name.
There's no evidence as to the content of the...
Or who the caller was on the voicemail.
I don't believe there was, Your Honor. The evidence went to the fact that the victim made these calls to her lovers.
So what evidence was there that the defendant learned of Christine's invitation for a threesome from Vigilant?
I'm sorry, Your Honor. Would you-
What evidence was there that the defendant learned of Christine's invitation for a threesome with Vigilant?
Well, that goes to the second issue. The problem is that the defendant wasn't allowed to show that the defendant learned from Vigilant about this threesome statement. Am I addressing the point that you're?
Well, I mean,
Vigilant threesome
but do you
statement?
agree that it would be relevant only if there was the ability to establish or to have evidence that the defendant learned of it?
We do.
And what evidence was there that he, or proffered, that he had learned of it?
Well, there was the police report in which the problem here was Mr. Vigilant was asked about this statement. He testified he didn't remember the victim making it, he didn't remember telling the police about it, and he didn't remember telling the defendant about it. So defense counsel
I thought he actually said, no, I didn't tell the defense counsel.
did say, no, I didn't, and then
Twice.
after that, and on the same page in the transcript, he said, I don't remember. That was his final word on it.
But do we have the police report?
The police report, for some reason, was not marked as an exhibit, but there wasn't no dispute about what it said.
But
We-
isn't there a dispute as to whether or not there was any question about whether or not he told the police that he had told the defendant? There's
I
there's
think
nothing in
it's
the police report that ties him to telling the defendant.
It's agreed. There didn't seem to be, defense counsel wasn't claiming that the police report said that Vigilant had told the defendant.
Right.
All that's in the police report is that Vigilant heard I'm speculating now, but it was assumed that all that's in the police report is Vigilant heard the victim make the statement, and he told the police about it.
Yeah.
Now, defense counsel, but the problem is, Vigilant doesn't remember any of this. So defense counsel wants to use this report, show Mr. Vigilant, does this refresh your recollection about this statement?
But even if it did, it doesn't connect the dots up to the defendant knowing
Well,
about
it doesn't so far.
So what
but
would,
if we
is there any
refresh-
evidence there about any prior relationship between Christine and Mark in a sexual manner?
I don't believe so. But if you show Mr. Vigilant the police report and it has the statement in it, would you like to participate in a threesome? And it refreshes his recollection about the statement, then maybe it'll also refresh his recollection about telling the defendant about the statement. And I'd point out that there's a specific offer of proof. Vigilant, first of all, he testifies that he did speak to the defendant that night, right after the time when the defense says this statement was made. He calls the defendant up at home. That's the first thing.
That's to say he's not coming over.
Well, yes, according to him. He also claims not to remember the statement, which...
Oh, but
which
isn't this the only part that he actually says? I agree that the last thing he says is, I don't remember, but it's the only thing about which he says, no, I didn't, twice. I mean, in other words, he doesn't say, no, she didn't call me. He doesn't say no, anything about that. He just says, I don't remember.
Well, he says two different things, and the jury is free to accept either one of those things, so the defense should be able to show by some other means one of the things that he's already testified to. But
And really, how does this add anything substantial to the fact that he would have known that his wife had been on the phone that evening with her two current lovers, as opposed to someone that, there's no information that she even had a prior sexual relationship with Mark?
would it add anything substantial, is your
Yeah.
question? I'd say yes. The fact that she is affirmatively proposing to one of their mutual friends this threesome on the very night when she's supposed to be coming over. They're thinking about reconciling. She's thinking about moving back in with her son.
She has two conversations with her current lovers,
Well, that's true, but it would have,
which he knew about. Those we were clear he knew about.
I think something like, would her proposing a threesome immediately before she goes home to the defendant would add something substantial to the heat of passion defense. I just want to point out, too, that defense counsel made a specific offer of proof during Mr. Vigiant's testimony that She said, based on information from my client, that Mr. Vigian did call up and tell the defendant about the threesome statement. So you have Vigian admitting that he did talk to the defendant that night, and a specific offer of proof that he told the defendant about the threesome statement. The offer of proof, the court can find in volume 8, page 164. Based on my arguments on those 2 points, we'd ask that this court reverse the defendant's convictions, and we'd also ask that the court give serious consideration to reducing the verdict to second-degree or manslaughter.
Now, are you waiving the argument about the instructions?
The argument on the instruction, I believe, that, unfortunately, the court was not informed of this, but,
Well, actually, we did get something yesterday.
well, yes, until yesterday, yes, Your Honor. The Commonwealth brought a motion to correct the transcript as to argument 3. We did not oppose that for the reasons stated in my letter, so that argument is out of the case.
Okay.
All right, thank you, counsel.
Good morning. May it please the court, Hallie White-Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. With me at counsel table is Assistant District Attorney Catherine B. Folger, who was the trial prosecutor. Just as an initial matter regarding the motion to correct the record, the reason it did not get to the court until this week is my failure to follow up with the Superior Court, and I apologize for that. As regards the demonstration, the Commonwealth was required to prove every element of the offense. The defendant did offer to stipulate to causing the victim's death. He did not offer to stipulate to premeditating the murder. Gavin's testimony was essential to that. All the evidence of premeditation, that the defendant left the victim's unconscious body on the couch, walked into the kitchen, and retrieved 2 knives, one of which he used to stab her 6 times. All of that came from Gavin. The fact that she was unconscious all by itself does not establish that. It doesn't establish that he didn't have a knife right next to him, that he, in the heat of passion.
Didn't Gavin, he testified to that.
He testified to that, but he had, that establishes premeditation only if the jury credits that testimony. And a good deal of the...
Well, but the demonstration doesn't go to leaving the room, going and get the knives, and coming back.
But it does go to the victim being unconscious and making no further provocation or movement during the interim.
Mr. Brandt argues that there was, on that point, that could be readily inferred from everything else.
That could be inferred from, among other things, the ME's report. However, Gavin's testimony that he went into the kitchen, left her, went and brought back 2 knives, had to be believed in order for the jury to convict on first-degree murder. And therefore, his testimony about how she was positioned was relevant not just to the circumstances of the murder, but to his credibility. The jury had to find that he remembered accurately what happened. And his testimony about her position on the couch and the fact that it was the same as the crime scene photos was a big part of that. My brother argues that the fact that it was like the crime scene photos proves that it was not needed. On the contrary, that's precisely the point. Gavin didn't see the crime scene photos. It was important for the jury to know that what he remembered was what actually happened.
Was there evidence that he did not see the crime scene photos?
No, I mean, it's not in the record, but presumably no one showed the 6-year-old son of the victim the crime scene photos.
And there was no suggestion on cross-examination or anything like that?
He was not cross-examined.
He was not cross-examined, okay.
So it was essential to our proof. The Commonwealth did not choose its witnesses in this case.
I'm having trouble with this essential part. I mean, explain it to me again. Why was it essential?
It's essential so that the jury knows that what Gavin says he saw was
But then he's the one doing the
what actually
demonstration.
happened.
Well, So he does the demonstration and he's talking. Why does
He
that
does
make
the
it essential?
demonstration because the record shows that he wasn't able to articulate precise spatial
Different point.
relationships.
That's a
He
different
says
point.
she's on the couch with her head between the couch. That doesn't tell us anything. And so this brief demonstration, and I was in the courtroom that day. I don't think it took more than a minute. It's not in the record. But it was a single question: show us how your mother was positioned, not when your father was killing her, but when he was choking her, is what the transcript says. And this is at volume 9, pages 94 and 95. Can you show us how she was positioned when your dad was choking her? He does so. Briefly, Ms. Folger describes his position for the record. There is absolutely nothing in the record to indicate that this caused any additional upset in the jurors. It's true that some jurors were apparently, by defense counsel's representation, we had only defense counsel's representation. The judge says she did not see it, but that she would keep an eye on the jury. That 2 jurors were crying. The judge did not instruct them not to cry and could not instruct them not to cry, not to be emotionally moved by the testimony, but she instructed them not to allow any emotional reactions to cloud their judgment and their impartiality. And that had been an issue from the very beginning of trial. It was clear that this was an issue. We had, again, not of our choosing, we had an eyewitness to the murder who was 3 years old at the time of the crime.
So if the child were 16 as opposed to 6 at the time of trial, would your view be different as to the appropriateness of the demonstration?
Possibly, because I think a 16-year-old would be more capable of articulating. She was lying with her back on the seat and her head in the space where the back of the sofa meets the seat cushions, and she had her arms up over her head. A 16-year-old could possibly do that in a way that clearly the record shows was difficult for our 6-year-old. I mean, this is, I think an analogy for this is the sort of the question of reasonable accommodations for a witness with a disability. Gavin's disability in this case being his age and limited vocabulary and understanding of geometry. But to return to the main point, it's clear that this testimony was upsetting, as it would be for any juror. The defendant does not now say that Gavin should not have been allowed to testify. The judge was careful in selecting the jury to excuse jurors who thought that they might have a problem letting their emotions getting the better of them. And jurors were aware that the agreed statement of the facts that was read before jury voir dire included the fact that the victim and defendant's 3-year-old son witnessed the incident. And it was clear also from the fact that there were a number of charges where Gavin was the victim. Had there been any perceptible additional upset caused by the demonstration itself, I have no doubt that trial defense counsel, who was beyond assiduous in this case, who had already moved twice for a mistrial. She moved for a mistrial at the beginning of the day on day 7 based on some problematic testimony from the doctor who had, one of the doctors who had treated Gavin. She moved for a mistrial on day 8 when a witness looked at the defendant in reviewing her police report to refresh her recollection and said, he's a monster. She knew how to move for a mistrial, and I have no doubt she would have done so had there been upset specifically caused by this demonstration. Moving on to the question of the supposed sexual overture made by the victim to Mark Vigent. This court asked what evidence there was to show that Vigent communicated that overture to the defendant. The short answer to that is none. There is no evidence that he communicated.
You do have 2 things. One, that he called the defendant.
He called the defendant.
And we don't know the content of that call. I'm not sure where the evidence came that he wasn't coming over. Who provided that?
Vigent testified, I called him and said I wasn't coming over, and the defendant said, cool.
Okay. but that conversation could have had more. So you've got him calling the defendant.
Speculatively, yes.
Well, just hold, okay. You've got him calling the defendant, and you've got the police report about the conversation.
And the police report is not part of the record. Defense counsel did not move to mark it for identification to preserve the record.
Okay, but there's no dispute that it.
There's no dispute that the record, that the transcript actually makes clear, looking at, this is roundabout page, volume 8, page 163. The judge asks defense counsel, show me where you see that in the police report.
No, I
And she
understand
points,
the police report
but there's-
doesn't, but it does talk about the fact that she, that is Christine, he says, Christine proposed this threesome.
yes,
So you've got those two facts, right?
yes.
And you're saying that's no evidence from which one could, in good faith, ask the question,
And defense counsel did ask the question.
and he answered, no,
He
no, I
answered
don't
no,
remember.
no, and the fact that after the question had been asked twice and answered twice, she badgered him into saying, I don't remember. After which, she made no effort to refresh his recollection. Now, arguably, even though it had already been asked and answered, if on the third try she finally got him to say, I don't remember, arguably at that point she could have said, I'm showing you a police report, does this refresh your recollection? And even though the record clearly indicates that the police report does not say that he told the defendant
So why
about
would
the
she
overture.
possibly, what would be the good faith basis to show in the police report for that?
You can use anything that might refresh your recollection. As we all learned on the first day of law school, she could have approached the witness and say, I'm showing you a ham sandwich, does this refresh your recollection? And the fact that the information is not in the police report is not a bar to using it to refresh his recollection. But she didn't try to do that at that point. His answer was no, and that's what we're left with. And if the jury, I still maintain that it would have been a speculative leap to say, he said he didn't, but maybe he did. There was no evidence that he did. And in any event, first, that evidence was cumulative. There was abundant evidence of her infidelity. There was abundant evidence that she was continuing to contact her lovers on the night she was killed. Additional evidence that she wanted a threesome with another man it would have added nothing to that calculation.
Well, that's not entirely fair, because there has to be a sudden revelation in order for it to trigger reasonable provocation. And
That's right.
And it was not a sudden revelation that she was having sexual relationships, I think, with these other two men, but it would have been a sudden revelation that now she'd moved to a threesome.
But that sudden revelation would have come, if it came at all, at 8:01 that evening. That's when Vigen's call to the defendant happened. Gavin testified when they got back to the apartment, my mom and dad were fighting and looking for their phones. We all went to sleep. After they got back to the apartment, they all went to sleep. Whatever provocation occurred as a result of that phone call, the defendant recovered control sufficiently that Gavin could say, we all went to sleep in the bedroom. Obviously, the 3-year-old child doesn't know what happened after he went to sleep, but the defendant had recovered himself enough that they could all be in the same room and put Gavin to bed.
what time they went to sleep?
We don't know what time. It was presumably sometime shortly. What Gavin's testimony was, we came back, they were fighting over the phones, we all went to sleep. I woke up and I came into the living room. We all went to sleep in the bedroom. My mom and dad were in the bed. I was on a mattress on the floor. I woke up and went into the other room, and he was killing her. So
Do we have a time of death?
we don't have a time of death. And it could have been 15 minutes. It could have been 4 hours. We don't know. But it was the defendant was in control enough that they could put Gavin to bed. Vigent testified that the victim left his garage to go to the defendant's apartment sometime between 7:30 and 7:45. She called Gary Hoey at 7:47, Sully at 7:49, or it might have been the other way around. Those calls were 7:47, 7:49. Vigent's call is at 8:01.
And the voicemail, was that a call to her?
My understanding is that it was a call from her phone to her voicemail. So it was
From her phone
it was
to her voicemail?
her phone checking the
Oh,
voicemail.
checking voicemail. And do we have any
That's my understanding of what
time
that
was
was.
that?
That was at 10:06, 10:08. But we don't know who was making that,
And do
who
we
was
know what the
checking
content
voicemail.
was of the voicemail?
Sorry?
Do we know what the content was?
I don't know if we know that they're, no, I don't think we know. And it also could have been, she could have been already dead by that point, and the defendant was,
Could have been checking
Checking her
voicemail, or she may not have been dead, and he could have been checking voicemail.
and he could have been
but-
checking her voicemail. We don't know.
but
We know that
would
there was a call.
matter only if we knew what the content was of the
Right.
voicemail.
Right,
And we-
exactly.
And we don't.
And we don't know. So the timeline, even in the light most favorable to the defendant, defeats any claim that this call from Vigent was a provocation sufficient to cause him to lose control and not regain it. If there are no further questions on that issue, there is no reason for this court to reduce the verdict in this case. This was a selfish and cowardly murder that was followed by a half-hearted but equally selfish and cowardly attempt at suicide. The best that can be said about it is that the defendant wanted to kill himself and didn't much care what happened to Gavin. It's a breathtaking indifference to his welfare, and unfortunately, it wasn't the first time he showed that kind of indifference. There was nothing new he learned that caused him to lose control. He choked her into unconsciousness, left her in the living room, walked into the kitchen, chose 2 knives, picked one of them, dropped the other, and stabbed her 6 times. The jury had the question of provocation squarely before them, and they rejected that claim. This court should not second-guess that determination. The Commonwealth asks this court to affirm all the convictions. Thank you.
Thank you.
Counsel.
All persons having anything